All right, our next case is going to be Long versus Family Support Services of North Florida, case number 23-1217. And when counsel for appellant is ready, so are we.
May it please the court, Brian Gowdy on behalf of the Longs, the siblings. I want to thank the court first for keeping this time. I appreciate the fact the court didn't reschedule. I would like to reserve 5 minutes for rebuttal. We have 3 issues in this case, and I kind of want to just look at them globally. The first issue dealing with the jury instruction, the remedy be a new trial. The second issue dealing with due process and a partial judge, the remedy be a new trial and a new judge. The third issue dealing with the how to proceed note and its admissibility relates to damages. So I will concede that if you don't reverse on issue 1 or 2, either one, you have to reverse on to get to issue 3. Also, I will concede that you have discretion not to consider that issue and let the judge consider it again on remand, and I think if you decide that we're entitled to a new judge, that would probably be appropriate. So I'm going to spend most of my time on issues 1 and 2, but of course we'll answer any questions that the panel has on any of the 3 issues. In the closing argument below, the counsel for the agency, the defense counsel, said this to the jury: there's no rule, statute, anything that says any particular kids have to be placed at particular places. That's at the bottom of page 2936 of the transcript, bleeding over to 2937. That was wrong as a matter of law. The proposed jury instruction that was proffered by the plaintiffs below asked the judge to read both the 2006 and 2016 rules from DCF. And
so both of those rules you think applied, correct?
Well, the 2006 rule applied, yes. Yes, the 2006 rule applied to the placement in Miss Brace's home, and then the 2016 rule applied to the later placement in the Long's home.
That's the ones that adopted the children,
correct? But okay. Before they were adopted, there was a foster placement, and that's what
we were requesting both of those rules to be integrated into the jury instruction, or counsel below was, correct?
Yes. I think that the whole problem started with the placement in January of 2016 into Diana Brace's home, where it was at that point that Matt, the brother, who had a history of sexually abusing others, was placed into Miss Brace's home, where there was a younger child, his sister, Patty. And that happened in January of 2016. The rule didn't take, the 2016 rule took effect in May. So at that point, the 2006 rule was operative. And FFS, the agency, knew this. If you look at the testimony of Miss Annan, who is the head of central placement, she talked about this rule. And in fact, she sent an email that's in the record to the people at Daniel highlighting this rule.
Which section of the rule, and I'll just kind of get to cut to the chase, which section of both of the rules do you think applies to Family Support Services in North Florida?
Okay, so I'm going to start with the 2006 rule. It's subsection 11, and what it says is when it is necessary to place a child who is an alleged sexual offender, so that's Matt, and is exhibiting or has exhibited sexually inappropriate behaviors, that's still Matt. The person making the placement, that's FSF, that's its central placement unit. It admitted in its answer that it retained the placement responsibility. It is the person making the placement.
So opposing counsel argues Daniel Memorial was actually the person who made the placement. So can you clarify that or address their argument?
Right, so they subcontracted Daniel Memorial to be in charge of case management. And Daniel Memorial was also sued, and Daniel Memorial also had responsibilities with respect to placement. But it was undisputed below, based on the contracts and the evidence, that FSS was required to authorize any placement, and that FSS had the ultimate responsibility and authority on making a placement. They're free to try to shift blame, and Daniel would have been on the verdict form.
Is the person making the placement and the person authorizing the placement the same person?
Yes,
In plain language?
yes. We
Okay.
explained that in our brief.
Is that based on the definition?
Well, there is,
It's on the definition that you're referencing?
no, so there is no definition in the rule for the person making the placement.
For placement, there is.
Oh, there
You
is for
referenced that in your
placement,
brief,
yes.
right. So is that the language that you're referencing, that you said the plain language takes care of this issue?
I think the ordinary meaning in the meaning of the person making. It's the term placement, no one disputes that this was a placement of a child to out-of-home foster setting. So placement's not the issue. The issue is the two words, the person making. And as we argue in our brief, the legislature is the lawmaker, not the person who actually writes the laws. The word making, and we put examples in our brief, the word making is synonymous with the person authorizing the placement. Without FSS's approval, the placement cannot be approved. Now, they're free to try to also blame Daniel, and that's, a Fabre non-party defense for them. But they can't absolve themselves of their own responsibility, their own involvement in making the placement. And just keep in mind,
So I saw that you referenced the contracts in your brief. What is the actual language in the contracts that you're referencing? Is that they retained the authority over the placements generally?
it's what we put in our brief, and I'll go to the page quickly. But we quoted it in our brief, Your Honor. Let's see what page. Sorry. All right, it's on page 7 of our brief. You first have the DCF contract, which is the contract between DCF and FSS. It says that FSS was required to secure, approve, and review all relative and non-relative placements under FSS's supervision. And then it says in the subcontract between FSS and Daniel, and it's record page 5487, paragraph P of the contract. All placement moves were required to be authorized by FSS. It actually uses the word must. We put required in our brief to try to make it shorter, but you will see the word must on page 5487, subparagraph or paragraph P of the subcontract. So whatever FSS might have subcontracted, they never subcontracted their authority to authorize the placement. And it even says in the subcontract on page 5585 of the record, Daniel was required to work cooperatively with FSS and its departments, including the Central Placement Unit. And, Your Honor, I guess there were two witnesses at trial, Ms. Annan, who was the head of the Central Placement Unit, and Mr. Pomar, who was a placement specialist. And I just sort of want to ask rhetorically, what else were the placement unit and the placement specialist doing other than placing children? And to say that they're not responsible is contrary to their own witnesses' testimony and all the emails. The FSS constantly was emailing the people at Daniel checking about the placements. So I think, and I would like to also point out that what we're arguing about is not the basis of the trial judge's ruling. The trial judge didn't look at the evidence. She said right there at the charge conference, it's not an evidentiary question. What the trial judge ruled was that because Daniel signed the safety contract that has to be signed between the person making the placement and the caregivers, that because Daniel signed that and not FSS, Daniel was the sole person making the placement. And as we point out,
So you're arguing the jury should have been allowed to make the decision as to who the person was making the placement?
well, it should have at least gone to the jury, yes. Yes, and I think as a matter of an instruction, FSS was the person making the placement. We're not trying to preclude them from apportioning fault to Daniel. Our point is, though, that this was the law. It's in plain English in a rule. And it was presented at trial through a joint exhibit. Witnesses were asked about it. Our counsel argued it in closing, and then their counsel got up in closing and said, there is no law. There is no law. And argued, don't listen to what plaintiff's counsel said, you have to listen to the judge. And the judge refused to instruct the jury on the law because she misinterpreted, and I think this is completely de novo, she misinterpreted the regulation. So I think it's clear on issue one, it is teed up as a question of interpretation of a regulation, no deference. There was clearly evidence in the record that FSS was the person making the placement, and the judge didn't rule otherwise. That's what they're arguing on appeal. But that's not what the judge ruled. And I also would say they made no effort in their answer brief to defend the judge's legal interpretation, which sort of segues into my second issue, unless there's more on the first, which is the judge came up with this legal interpretation on her own. It was not proposed by FSS. It was her own creation, and this happened repeatedly throughout the trial. She repeatedly interjected. And it said in the answer brief that the judge has a duty to keep the jury from hearing the inadmissible evidence. And I understand the First District said that in the Lee case from which Judge Makar dissented. And I would respectfully ask this court that to hold that's wrong. Trials are conducted by the parties, and we have rules of evidence so that parties may object to certain evidence, but parties are allowed to stipulate to the admission of evidence that would otherwise be inadmissible. If the parties want the jury to hear hearsay, they can. If the parties want the jury to hear evidence that might not pass Daubert, they can. And when a party doesn't...
I have a question for you on this interjection issue, which...
Yes.
Again, as a longtime trial lawyer, you kind of like it when that does not happen. Do y'all object to it at all?
Yes. So
When and where? I really need to know that. And if you've got it right now, that's great. If not, you can give it to me when you get back up for rebuttal.
no, I have it. We cover that in the reply brief. And first I want to be clear about the issue being raised on the appeal. It's not about any particular comment the judge made. The issue on appeal is that we had a partial judge and an unfair trial. And there was not any single comment that
Get to where you actually objected
in the
to
motion
any of
for
those.
new trial.
No, to any interjection by the judge during trial, was there an objection from plaintiff saying, Judge, please don't do that? I know it's uncomfortable to have to do it, but
Right.
tell me
The
where that is.
Yeah, so it's not, we didn't do it at trial. And I said that in the reply brief. We did it in the motion for new trial. And I would suggest that when you're raising an issue on appeal about an unfair trial and a judge who conducted an unfair trial, that is the appropriate place to raise it. I make a couple other analogies where you raise issues for the first time in a motion for a new trial. If you have issues about the verdict being inadequate, you raise that in the motion for new trial.
But the verdict happens at the end of trial. These interjections were during the trial. Again, that's what concerns me.
Yeah, I understand your point, and I think I would say you've said, first of all, you acknowledge as a former trial lawyer, it would be very, it would be strategically a disaster to be sitting up there telling the judge you're violating my due process rights. I would point you to a case from this court, JJ, where your co-panelists were on, where that's not how it was preserved. My position is that the appropriate way to preserve it is in a motion for new trial. And if you don't agree with that, then we do meet the standard for fundamental error here on that second issue. I've got 5 minutes, so I'd like to reserve all that unless there's questions from the panelists.
Okay, I think you're set.
Good morning. May it please the court. I agree with Mr. Gowdy's assessment of what the issues are, and so I'd like to start also with the instruction. And I do think we have a significant preservation problem, and one of the reasons I say that is not because it wasn't discussed, but because the exact instruction that they wanted was never presented to the court. In their reply brief, the appellants state that on page 933 of the record, they preserved what they wanted. But if you look at the instruction on page 933, it simply referenced the rule 65C 28.004, no subsections, no years. And that's all they presented at the preliminary hearing and their instructions that they've filed in advance of the trial. And then there was a very, very lengthy discussion at the pretrial hearing on January the 3rd where they withdrew their request for that instruction.
They later asked for that instruction
Yes, they did.
again,
And as
correct?
they went through trial and we got to the fact that they'd stipulated to the rule as part of the evidence, the judge said, "Oh, are you asking for that?" And about the fourth day of trial, they said, "Yes, we are asking." That was all they said at that point in the trial. And they never briefed it, even though that was day 4, day 5. They still had multiple days left. And let me just point out that this was probably one of the very key issues in this case, is does FSS have a concurrent duty with these placements, right? There is no question that Daniel was heavily involved in doing virtually everything on the ground related to this placement. And other than supervising and checking in with them, does FSS have this duty to have a concurrent duty of placement? Plaintiff never, ever briefed that issue for the trial court. Never cited a case, never cited a rule, never presented any argument to this court as to why their theory, they said that's my theory, but they never presented any legal authority to the court on why that was true. It came up multiple times in hearings, and the judge repeatedly asked for a case law, for authority, for rulings. They said, yes, we're going to ask for this instruction. That literally is the only thing they said at that point in time in the 1200 section of the record, of the transcript. Then toward the end, they got into the big, long discussion, and this is where it gets incredibly confusing. And I think even if you think the judge may not have, maybe you do think there are concurrent duties, right? The way this instruction would have been presented to the jury is incredibly confusing, and I'll explain why. Subsection 10 of this rule dealt with the victim of the sexual misconduct, which would have been the sister. And I'm going to refer to them as the sister and the brother to try and avoid violating their confidentiality. So
I understand we were using pseudonyms before.
But then as I was reading the transcript, there were first names, and so I'm not going to confuse them. I'm just going to call them the sister and the brother. And the sister would have been under subparagraph 10 because she's the victim. And the terminology used for her pretty much never changed between 6 and 16. And when they came in at the end of trial, they didn't ask for subparagraph 10. They only asked for subparagraph 11, which would only deal with the brother. And they never specified exactly, I mean, they kept saying 6 and 16, and then they talked about who was the person making the placement, and they argued about whether or not it was Daniel. Now, if you look at the language of that rule, and I have it with me.
Which rule, the 2006 or 2016? Both the rules reference person making a placement?
They do, but not exactly in the same way. And what I want to point out is when you talk about subsection 10 of the victims of sexual abuse, the rule says in B, which was page, I can't remember what page of the record this is, but it's in the record. When placing a child who's been a victim of sexual abuse in out-of-home care, a written safety plan shall be completed by the person making the placement and the out-of-home caregivers and signed by the same. So clearly the person who made the safety plan.
What about subsection 11?
And signed this, and so that's where the first time I see this person making the placement is in subsection 10. And in 11, they talk about what the person making the placement is supposed to do, and it doesn't say who's going to have to sign it in.
Didn't they argue below that that applied to the brother?
Subsection 11 applies to the brother, and that's the one they were asking for, which of course was not in the jury instruction. They informally, verbally requested is that this will only apply to Michael's claim or the brother's.
The judge denied that, correct?
Well, they denied that the request for subparagraph 11 should be read into that, but again, find where the plaintiffs ever specified what they wanted the judge to read to the jury in regard to the brother's claim. Because they never ever said in the instruction, and this is where it gets confusing, how are they going to tell the jury that they only want the jury to read this rule as it concerns the brother's claim, and please only look at paragraph sub 11, and that's how we get into this very convoluted and then very confusing instruction on we have two statutes, it applies to this, it applies to that, it applies to the brother, it doesn't apply to the sister, and we have to decide who is the person making the placement. And subparagraph 10 gives you an indication, and remember we have to read these rules as a whole, we have to take the statements at their face value. They already said, the legislature or the administration, actually the DCF said that the person making the placement is the person who signs it, signed by the same. They said that in 10. They then used the person making the placement just name, right? That's the phrase they use. But in subsection 11, they don't specify that that's who's supposed to sign it and that that's who makes it the safety plan.
Did FSS have any responsibility for reviewing or approving the placement?
They have to approve it. And I think that's in their record. They have to approve it. They have to supervise. That's the defense counsel.
If they approve a placement that's at odds with the rule, is that okay, to use a very common sense word?
I would not think so.
Okay. And was this placement permissible in terms of placing the older sex offender, if you will, with the younger victim in the same household?
I think that if you look at the rules, that if, as long as they had the safety plan and the restrictions and the rules and guidelines in place, then it was. In other words, there's a lot of factors that have to be considered. And sometimes the factor of keeping the children...
The initial placement was Miss Brace.
Right.
She got the safety plan like the night before and was not happy with that.
That's some of the evidence. That evidence is disputed.
The safety plan basically was, don't leave them alone, but she was a single working person, correct?
Well, and I think, again, I think that's disputed. The evidence on that is disputed.
It's disputed that she was single and
No,
working?
no. No, I apologize, Your Honor. That's not disputed. She was a single mother.
Isn't that, I mean, again, we're not talking about whether you win or lose here with the jury. The question is whether this instruction should have been allowed. And so whether that's disputed or not, that was, as Judge Edwards said, that was her testimony, correct?
Well, but the dispute in the facts as to whether or not this instruction was complied with, I think that's one of the reasons why this is not a de novo review, that's why this is an abuse of discretion. And that's when we get into the court's discretion in addressing whether this is going to be so confusing because we're talking about different siblings and different years and different placements and all those things. And
Did the judge actually say it was confusing, or did she say this is an evidentiary issue?
She did say this is not an evidentiary issue, but I think she also said that this is confusing. The judge was clearly confused.
You raise an agency issue in your brief, and so you say the lead agency is not liable in torts for the act or omissions of the subcontractors or officers. But did the lead agency here, as argued by your opposing counsel, didn't they retain placement authority in the contract?
Again, I think that there's some supervisory positions because, again, they were responsible for the money that would go through. The placement unit would be responsible for keeping track of where the children were, making sure the money went to the right places.
So I have the language of the contract that it says subcontractor must fully cooperate with FSSNF, Kids Central. All placement moves must be authorized by FSSNF. Isn't that a little more than just
Yeah,
oversight?
yes, I'm saying that they were overseeing it, but the decisions and the carrying out of this administrative rule in terms of the safety plan, that was delegated to Daniel. And there's no dispute that we think that Daniel had the responsibility for the placement here while we were supervising and authorizing. And the management, so to speak, is not the same as the person who makes the placement. But again, I think the court had the discretion to deny an instruction that was going to be very, very convoluted based on the fact that, again, the plaintiff never specified exactly how they wanted this presented. They never presented the court with an explanation of concurrent duties or how that works, and they never really laid out what this instruction should look like. They left it to the very end of trial to make some arguments on one morning in a few minutes type of thing, and that's where the problem becomes. And I think that is a preservation issue, because I think if you want an instruction, you put it in writing, you specify it, and once you've been told at least 3 or 4 times that the judge is having a problem with it, you should be prepared to give the judge the legal authorities that back you up. None of the arguments made by a counsel here, other than concurrent duty, was made to the trial judge. They did not parse out the rule and try to say, well, it says this, and making means that, and here's all this. They didn't do any of that. And I think that the language of the rule itself, where it talks about the person making placement is the same as the person who's signing it, I think that's pretty well said in the rule itself. Now, when you get into 2016...
Were the rules actually in evidence? I thought they were stipulated into evidence.
Yes, they were.
They were?
Yes.
Okay, so they were fair game when counsel for defendant got up and said there's no law at all requiring?
So what the counsel said is that there is no law that says a child is entitled to a particular placement. In other words, you can't get up and say that the rules require that you place me with my aunt or my siblings or with this couple or that couple. That's what the counsel was saying, is the rules govern what criteria you can use, but as long as multiple people meet that criteria, you don't have a right to any particular placement. And I think that's what the fair understanding of what she was trying to say.
Placement where the violator or abuser is older than the younger victim, don't the rules or regulations say that's not a placement that should be made?
I think the rules say that that is not an ideal placement. They do not say it's prohibited. And in other words, it's prohibited if you put in no restrictions, no rules, no safety plan that's to address it. But there are times when, even though they're an aggressor, there's an emotional bond and there's some other factors and criteria that have to be considered. These family dynamics and the way the siblings behave, the sexual acting out is a symptom of many other things that are very interdependent. So children cannot necessarily be separated and improve, even though their presence involves some factors that are harmful.
Testimony, he seemed to be doing very well at this ranch, and then they moved him. So, I mean, that was the testimony, correct?
That was the testimony from some of the people.
Was there a disagreement on that?
That he was doing well at the ranch?
Yeah.
I think that they felt he would do better when he went somewhere else.
And they being whom? FSS?
No, I think the Daniel people made some of those decisions, so yeah.
Let's talk about the judges piling on, adding grounds to objections. Is there any justification for that?
So I think if you look at Judge Deering's conduct through the pretrial hearings and the trial, we have a judge who is an experienced trial judge who anticipates what everyone's going to make as an argument. She started that January 3rd hearing with an anticipation of what plaintiff was going to say, what defendant was going to say, and she wanted to get into the meat of it. And I think that is where she gets this. And also, because she is already anticipating objections, and I do believe the record supports that Ms. Osberger stood up more than once, and that's why the judge knew she was going to object. So I don't think she was making objections for the defense. There may not be okay, you stood up in the record, but I think there was other indications.
Actually, there is 1 or 2 places,
There
I
is,
think.
exactly.
But I mean, like this one, and it's on page 906 of the transcript. Ms. Osberger says, objection, Your Honor, calls for speculation. The court sustained, also as to foundation sustained.
Well, I think speculation
Where does a
is
trial
foundation.
judge get off on adding grounds to an objection?
And again, I think this judge is just simply pointing it out, but I also think speculation and foundation can be referring to the same thing. They're speculating because you haven't established they have the foundation to know that information. So it's almost 2 sides of the same coin.
Objection, Your Honor, calls for hearsay. Sidebar. What's the relevance?
Well, because if it's highly relevant, and there may be an exception to the hearsay rule.
Relevance and hearsay are two different animals. I mean, that's what I don't understand. When you see a lawyer stand up, I can see the judge going, okay, let's have a sidebar. I don't see anything wrong with that. What I question is when the judge starts adding objections that the lawyer didn't make, and after a while, Ms. Asperger is apparently very bright. Oh yeah, that too, Judge. It's kind of like I agree with the judge, and we've all been there. If the judge is doing a great job arguing against the other side, you pretty well shut up or join in. And if it happened once or twice, you understand. But it did happen an awful lot compared to most trials I've ever been involved with.
Well, and the other interesting thing is that the judge was not wrong about her points, and there is no...
Doesn't matter.
Well, it does, but there's no indication that it influenced the jury or that there was any unfairness. The question was inappropriate on both grounds, and the evidence was disallowed, and that's as simple as that. Oftentimes, as you've indicated, if I feel like I'm winning my appeal, I don't spend the full 20 minutes up here having a conversation. I very quickly sit down before I talk myself into a loss. So the fact that Ms. Augsburger was smart enough not to talk herself into a loss, I don't think is a fault to either Ms. Augsburger or Judge Deering. But the fact is they were
Here's an objection
objectionable.
made, a lack of predicate, lack of knowledge, and the judge adds, and it calls for a legal conclusion for which she's not qualified.
Well, perhaps she was trying to get the plaintiff to stop asking the inappropriate questions or to perhaps lay the correct foundation and lay the
Honor,
correct...
objection, relevance, the court, and leading, sustained. I mean, this is not an evidence class. This is a trial where the judge is supposed to be a neutral arbiter. This is not a situation, again, like we maybe had in our last case or alluded to, where somebody was doing something terrible and needed to be called down. This was a judge adding, don't forget it's leading.
Well, or was she
Again,
just making the record that in fact it was also leading? Because if it was done out of the presence of the jury, it is more educational than it is harmful.
Educational to whom?
Both, because apparently she had to do this a lot because Ms. Beaver's questions were...
And I don't disagree that the trial counsel could have been more on their game. Don't get me wrong. But again, when the judge starts adding on to, I mean, it's one thing if you got 10 leading questions in a row and you see the other counsel stand up and go sustain because you know this is the 11th leading question in a row. But to keep adding grounds to one side's objections, was the judge doing that on the other side as well? I didn't see that.
But was she advocating for the defendant in doing that, or was she just simply trying to get the rules of evidence into the litigant's position? I think the judge is...
Whose job is it to make objections?
Well, I think it's the parties.
I don't think there's any doubt about that, and that's why I keep asking you, why does the judge then, why is she making objections?
And again, I think it was not favoring one side or the other. I think one side asked more improper questions.
Did she add grounds to objections made by the plaintiff?
I don't know that there were very many, if at all. Again, it was a 3,000 or 4,000 page transcript, so I can't say that I remember every one of the exchanges. It certainly wasn't anything anybody pointed out. So let's put it that way. So I do think that the judge was not an arbiter in the sense of advocating for or against a party. I think the judge intervened in a way to keep the rules of evidence and keep the evidence that was in trial admissible, but otherwise, because again, she was correct, it was inadmissible and she kept it out. And as long as the jury wasn't hearing it and the party was not putting in inadmissible evidence, I don't think there was any advocacy there for the defendant at all. Again, what difference does it make if it was speculative but also an insufficient foundation as long as she kept it out? Maybe she was just, I think she speaks almost more unfiltered, like that was what's in her head, so she says it out loud. And perhaps that's not the best judicial decorum, but I don't think it made her an advocate. And I don't think the record shows she was advocating, because I do think the record shows she got on the defense for not raising issues.
What's the impression the jury gets from that? She might not have intended that, but what's the impression the jury gets from that?
That perhaps the attorney isn't asking correct questions, which would be an accurate impression.
Or that the judge is favoring the attorney.
I don't think by simply saying a few other things it leads to that. So
How
the jury continued to ask
How do you sustain
questions.
an objection that's not been made? And again,
Well,
I'm
you just
looking now at
described the
1154. Ms. Osberger, I'm sorry, lack of predicate, Your Honor. The court sustained as to leading. She sustained an objection that wasn't made. And you telling me that's not being an advocate for one side or the other?
Was it also
Couldn't certainly be seen
objectionable?
that way?
But was it not objectionable for the reason Ms. Augsburger raised?
Then overruled on that ground. Is that your basis? Do you have anything else? I mean, you know, I've been,
No, I'm saying it was objectionable because of Ms. Augsburger's reason. It was, you know, and then she said it's also leading.
no. Sustained as to leading was all the judge said. Not sustained as to lack of predicate, sustained as to leading. The judge made an objection and not surprisingly granted, sustained her own objection. That's what they're talking about.
And I think the judge had a lot to say, but I don't think it rose to the level of advocating for one or the other. And I think most of the statements were made out of the earshot of the jury so that they didn't influence the jury. So I think I'm out of time. Is there anything more?
All right, thank you. Any other questions? Thank you.
Thank you very much.
Paper you need is always at your desk or in a box.
I still don't have the right one, but I'm going to go. First, on the preservation issue, I want to point out that there was a motion to dismiss raised by the defense mid-trial and a response on the same issue dealing with the rule. So I don't think anybody was surprised at the charge conference. Number two, as was pointed out, at page 933, there was a proposed instruction based on 40109. We cited the rules. What I'm hearing the fault for is we didn't put the text of the rules in the proposed instruction. I don't think that was required, but if to the page 2792 of the record, there's a clear trial counsel saying, Judge, I have copies of the rules here for you. There was no confusion about that. Number two, all I heard was this would have been confusing or overbroad. Well, number one, that's not what the trial judge ruled. The trial judge ruled that the person making the placement was solely Daniel. The trial judge never ruled that what was proffered was confusing or overbroad. Number two, that was not argued below. Had it been argued below, we would have had the opportunity to perhaps reduce the instruction or make changes to it. It's unfair also to the appellant to raise an issue for the first time on appeal. You're here to review the trial judge's decision. And the decision was that this, and I want to read the language because it's been misstated by my friend on the other side. It says a written safety plan shall be completed, by the person making the placement. It's an obligation on the person making the placement. It's not a definition of the person making the placement. So effectively, because FSS did not follow the rule, they say they don't have to follow the rule. That's their circular argument. We breached our obligation under the rule, so we're not bound by the rule. And that's what the judge agreed with, and that's the ruling you're reviewing. I also want to really hone in on the text of subsection 11, because there's been some confusion about applies to Matt or applies to Patty. This rule, subsection 11, applies to the placement of alleged juvenile sexual offenders. So it governs Matt's placement, but you better bet your bottom dollar it protects all the kids. Because the problem with an alleged sexual juvenile offender is he's going to do it again to other kids. And it does say, it's mandatory. It uses the word shall. You will not place a child like that unless he's the youngest child in the home, not in the room. You heard all this argument, they had separate rooms. You do not place an alleged sexual juvenile offender unless he is the youngest child in the room. In the home. Patty was younger than him, and she had been a past victim of his abuse. They violated the rule, pure and simple. And they told the jury there was no rule. There's an exception, though. If you do the placement in a treatment facility. Mrs. Brace's home was not a treatment facility, and that treatment facility has to have adequate video monitoring. There was no video monitoring in this home. They broke the rule. They violated the rule, and they told the jury there was no rule that governed their conduct. And just to pound home the point that this protects all the children in the home, it says right here in the rule about the vulnerability of other children living in the home. And it says right here in the rule that the reason you have to give the caregivers this written, detailed, and complete information is so they can avoid any unwitting replication of those circumstances. This rule governed Matt's placement, but it protected both Matt and Patty. And the reason that they're both victims and that Matt suffers post-traumatic stress is if you had an incest with your sister, that damages you for life, not just 15 months after the incident. We would never tell our veterans they couldn't provide evidence of their post-traumatic stress 30 years after the Korean or Vietnam War. Why did this judge not let the jury hear about Matt's post-traumatic stress 15 months afterwards? I'd ask the court to reverse, order a new trial judge be assigned, and thank you for your time this morning.
All right, thank you. We're going to take a brief recess, and then we've got another matter that we'll take up right at about 11 o'clock.